Let's be call now 25 CR 1617, State of Texas versus Kendra Petrie. Is that you?
Yes.
Present. And Mr. Adams, your attorney and the state's attorney. I'm looking at this indictment, which was handed up by the grand jury on October 29th of last year. And it alleges that on or about October 10th of last year in Jefferson County, Texas, you committed the first-degree felony of aggravated kidnapping. And let's see, the deadly weapon used, but aggravated kidnapping.
Because of your bodily injury, should have been.
Oh, no. Why don't you look at it? I think there's an issue here.
Well, there's ransom or reward.
A4. Aggravated kidnapping. Person commits offense of aggravated kidnapping, intently or knowingly abducting another person with the intent to hold them, hold them for ransom or reward.
Yes, sir.
What this is.
And I will be giving notice of a use of a deadly weapon. There's a firearm that was used to pistol whip this victim, according to her pistol statement. It had to be transported to Houston Hospital because of her injuries were so severe.
All right, this is a first degree felony under this law. And if they had used a deadly weapon, that's what you're intending to?
Yes, sir.
So this carries with it, if convicted, no less than 5, no more than 99 years confinement in prison or life in prison. Plus, if the deadly weapon is alleged, then whatever your sentence you get, your parole, you will not be allowed to be released on parole until you serve at least 1/2 of your sentence, whatever that will be. So what are we going to do?
Judge, I think there's 3 defendants in this case, and she's telling me she had nothing to do with this case.
On grand jury, otherwise in the DA's office, we're not going to dismiss it. We'll just set it for trial.
Yes, sir.
Let a jury decide. Okay, Milton Richard.
And also the paperwork on.
And also they're going to be filing a new indictment to include the firearm, which is more trouble. Milton Richard.
You got the paperwork on.
Judge, if we can pass on that one and come back to that one, I need to talk to defense counsel about that one.
What?
Milton Richard.
And I'm never going to get anything done today.
So,
Thought I had one.
yeah,
What about Robert Strout? What are you going to do with Robert Strout?
Robert Stroud is representing himself. He says he doesn't want more.
Hold on.
He filed the letter.
Yeah, I'll deal with him at the end. Yeah.
Yeah, he's
For those.
be his own
I
lawyer.
know, that's all of a sudden increasing in there. There's a seminar going on in the jail. That I think a lot of them are attending.
So you all right, let me get with this thing shit.
Yeah.
But we hit the plea on.
I don't
I do not have plea papers for that.
Mr. Walker.
Fakes.
Yes, sir. Batiste. There'll be a plea on the MTRP and it'll also be a plea on the.
Well, where's Mr. Walker's?
It's Aubrey Samuel, him on code. And
Oh.
co-counsel, I
It
can't.
may be co-defendants. That may not have been a party. It's a plea, so.
It's Batiste, you said? Okay, come on in.
And counsel represents the case, but we're co-cases on the motion or about it.
And that's what we're dealing with.
I'm sorry.
That's what we're dealing with.
Yes,
today. And we'll need Mr. Batiste. Thank you. Yeah, I'm sure enough.
I'm satisfied with 14.
Okay, on this one, we're talking Keontae Batiste, 25 CR 173 manslaughter.
Yes, sir.
There's another.
But there's a new charge on the,
I don't have a motion to revoke probation, and
Not in that one.
Oh, that's,
I'm leaving.
that's not that on that.
And that would be
Okay, that's one. So we're gonna put aside manslaughter. And we're dealing with burglary. And a habitation. Okay. 19-30968 is now called the State of Texas versus Keontae Orion Batiste. That's you, sir, right? Correct. You have to speak out for the lady. Okay. You were here with Mr. Samuel and Mr. Walker as your attorneys. Couldn't have gotten a third one? You got two good ones. There's a first amended motion to revoke unadjudicated probation. Is that what everybody understands?
Yes.
And that was filed on March 4th, about a year ago. Does the defendant waive a formal reading of this? Can we proceed in some?
Yes, sir.
And raise your right hand, sir. Do you solemnly swear, or your right hand, there you go. Do you solemnly swear or affirm the testimony and the statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lawyer. In summary, this motion states that on December 2nd, 2019, in this court, you were placed on 10 years deferred or unadjudicated probation for the second-degree felony of burglary of a habitation. Is that true? Or do you want to go on? I'm looking at 16.
The only one I require for sure is 14.
Number, let's go to 14 under the first amended portion of the allegations of violations of probation. Number 14 states that you committed the offense of manslaughter on or about January 4th, 2025 in Jefferson County, Texas, in violation of condition 1 of your deferred or unadjudicated probation order, which states do not commit an offense against this state or any other state or the United States. Is that allegation true and correct?
Yes, sir.
Make sure we got pause in this. Because there's so many different ways to commit manslaughter. Okay. Person commits the crime of manslaughter pursuant to section 19.04 of the Texas Penal Code if he recklessly causes the death of an individual. Did that occur in this case, sir? I'm asking you. That's what it takes on this. Did that occur?
Yes, sir.
All right. And are you admitting, based upon the facts and based upon your discussions with your attorney, that you did recklessly cause the death of another individual?
Yes.
Just in quick summary, what was the circumstances? How did the death occur?
It's represented in the indictment.
I don't have, yeah, but I'm looking at the motion to revoke.
25 DCCR 0173. Facts are that he was evading police, running at speed in excess of the posted limits.
Under this, there is an indictment 25 CR 0173 handed up on February 12th of last year by the grand jury. And this states that on or about January 4th of last year, 2025 in Jefferson County, Texas, that you, Keontae Batiste, recklessly caused the death of another person as you were operating your motor vehicle in excess of the posted speed limit. You failed to control your automobile, ran a red light, were fleeing from a police officer, and your actions caused your automobile to strike another automobile occupied by Henry Knoblich Jr., and who is called the complainant or victim in this case. And this also goes on to state that you used and exhibited a deadly weapon, namely an automobile, that in the manner of its use and intended use is capable of causing serious bodily injury or death. Is all of that true and correct as it is alleged, sir? Are you pleading true and correct to this allegation voluntarily and because it is indeed true as it is alleged? You understand that a voluntary and knowingly made plea of true to one or more violations of probation, that is enough to grant a motion to revoke probation. If probation can be revoked, you can now be found guilty and sentenced to no less than 2 nor more than 20 years confinement in prison. Knowing that, do you insist on pleading true today? I need a pad. I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading
Do anything.
truth, huh?
There's no moving papers.
You'll have plea.
Would like to better there. Would like to visit with one sec.
Oh, I thought you had something already,
No.
in the. What is the deal
If they agree to CC, that's
with, he's gonna be pleading guilty. to
That is not the agreement, Judge.
Oh,
There's apparently there's a misunderstanding.
okay. Oh, why don't we do, why don't y'all break,
yes, please.
talk, come back, we will pick this up where we left off. When you're ready, let me know. Okay.
You say that.
Jonathan Clifton?
We did not need him brought out, the file a motion for a medical examination. You know,
Should be right.
Swear I did say that. I hadn't heard that. I'm glad that.
I've got, Jonathan Clifton, right? 126 R 44. And there is a motion, what's called for a complete mental examination that has been filed by Mr. Dewswell on behalf of the defendant. Let's see. And where's the defendant now?
he's back here.
It states that that I would order him to be moved to a secure mental ward of a hospital, and that all costs of transportation and necessary and reasonable medical expenses be paid for by the state of Texas. I'm going to order an examination by Dr. Ed Rapon, but I'm going to let Dr. Rapon decide where all that's going to be. I'm not going to, the people are going to be stuck paying a bill that it may not be necessary by sending him to some hospital somewhere and paying for all of that. And then, Dr. Rapon having to travel to see him. He's at the jail now.
Yeah.
Right? And that's
It can be.
what I'm going to order is that. And the problem is this is the above motion for complete mental examination, but it's talking about sending him to another facility. That's not what I'm allowing here.
No, it can be done. With no objection to that.
Okay. The mayor on this day came on to be heard the above motion for complete mental examination of the defendant. Said motion is hereby granted. A mental examination is ordered to the extent that Dr. Ed Rapond licensed psychiatrist shall evaluate the defendant at the Jefferson County Jail. Sign this day. And that order is entered. And it will be processed. Thank you. I got, Randall Manuel.
But he needs to be brought out for a plea. He's already signed it.
Randall Manuel, please. Thank you. You need something.
Yes.
Wow.
Mr. Manuel, come on up, see this lady first. Thank you.
Yes. So then she's going to prepare for everything.
Go over there and see that lady. Thank you. Mr. Manuel has some fans in the crowd, apparently. Some fans.
That's my brother who recommended.
His brother.
Right here.
Have a seat, sir, please. Thank you.
Can you do two more for me? Anywhere on the hammer, and you could move the paper if you have an. So we get some. Anywhere. Thank you.
Right there, sir. Thank you.
Right here, sir.
And we call 25 CR 239, the state of Texas versus Randall Scott Manuel. You were Mr. Manuel,
Yes, sir.
and you were here with your attorney, Mr. Dusler, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
Mr. Manuel, in summary, this indictment alleges that on or about January 29th, 2025, over a year ago, in Jefferson County, Texas, this alleges that you committed the third-degree felony of assault on hospital personnel at hospital property, which is a third-degree felony by you, apparently, this states that you shoved a nurse against a glass shelf and caused bodily injury to the person. Do you understand what you're charged with?
Yes, sir.
Okay.
I don't remember doing that, you know.
Did you do it or not?
Yes, sir.
Okay.
Apparently, so.
This is a third-degree felony if convicted, and you face a term, if convicted, of standby. You gotta love this new stuff because it's doesn't work like they told us it would work. Degree felony means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range applicable for such a crime?
Yes, sir.
An agreement has been reached in your case, your particular case, where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. You would not be found guilty. And there would be terms and conditions of probation which are normal and customary, not only to this case, but also specifically to your circumstances.
Yes, sir.
Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
Here's the issue. This is all well and good, but if I place you on this probation, if you fail and you commit violations of your probation while you are on probation, you would come before me. I could revoke your probation and sentence you up to 10 years in prison then,
Yes, sir.
which you don't want. No, nobody would like that.
No, sir.
So it's going to be important that you understand fully what the conditions of probation are, and most importantly, you follow them.
Yes, sir.
And this will end fast enough because I can shorten probation for good behavior. Okay? And I do it all the time.
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
So how do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty and your attorney pleading, both of you pleading guilty voluntarily and because you are guilty? That's the gap.
Yes, sir.
Okay, I show you what's marked as State's Exhibit 1. Did you sign that document?
Yes, sir.
Understand it, discuss it with your
Yes, sir.
attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection admitted. Among other things, this states that you are mentally competent to enter your guilty plea. You are doing this freely and voluntarily.
Yes, sir.
You understand and appreciate the consequences of pleading guilty.
Yes, sir.
You have read the indictment, or it's been read to you. You were guilty of the crime charged and any lesser included offenses, and you were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, it states down here, so help you God.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. Is a pre-sentence report waived? All right, I'm a little unclear here. What do y'all want to do on the?
I believe that's what Mr. Dusler's looking for. Obviously,
Well,
it's
that's what
up to
he's
the
looking
court.
for, but it's
I'm not opposed, but you judge it, obviously, you're going to decide whether it's the 10 or not.
Don't know about this.
That's with the offense and with the challenges that he's made. And I'm not opposed to the 2 years, but if the court did allow for the 2 years, that he'd be on a mental health track there with probation, so he gets some assistance with.
If nothing further to add, I'm going to find you pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes, sir.
There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to find you guilty. I'm going to place you on deferred or unadjudicated probation for 2 years. There will be terms and conditions of probation, which are normal and customary, but also suited for your particular circumstances and needs. You will be placed on the mental health caseload, and we will be monitoring to make sure that necessary medicines are taken,
Yes, sir.
and you will be required to take properly as prescribed all medications. There are a lot of conditions in probation here. There's 36, but when people look at that and they go, "My God, that's so many." Most of these are requirements I have to do.
Yes, sir.
Don't commit a crime.
Yes, sir.
Don't associate with bad people.
Yes, sir.
Uh,
I better try not to.
support your defendants. See, all of those are things we all. I mean, that shouldn't be punishment. That should be a guidance of good life. You know.
Yes, sir.
Now, there are other terms, though, that are going to be special for your particular needs. So make sure you follow them. And also, you're going to complete what we call an anger management program, which helps people make decisions when they're under stress.
Yes, sir.
And pass that. Okay, please see the probation officer. Okay, thank you.
Oh, God.
Here's this one.
Oh. Change in the front. Change in the front. Thank you, Your Honor.
Yes, sir.
You go to the Richard, in Town, you go to the rest of them.
How about Cedric Williams?
Bring him up, please.
Oh, Cedric,
Yes, sir. I do not have anything signed up.
Cedric Williams, please, 24 CR 551. So we're gonna see what we're about.
Yes, sir.
Yes, sir.
Actually, he's gonna need to hear, the admonishments from you. He kind of got a raw deal. He's been in prison. He was bench warranted down here. He's been in prison a good while, but they did not issue a detainer for him until 2 months ago, December. So he wants to plead guilty, concurrent with the time served. But since they didn't issue the detainer on him ahead of time, he doesn't have enough credit. He's only got 2 months worth of credit. And he doesn't understand that. He thinks he's been.
What do y'all want? Is that what you want to do? What he's saying? Are you the lawyer on that?
Yes, Judge.
Bench warrant was 2 months ago. He's had an active warrant from the indictment.
I had Lacey run it. She said that the detainer only gave him 2 months, but
The bench warrant detains.
so
I don't think you knew where he was 2 months ago.
So, okay, I'm a little fuzzy about what you're saying, but what is it y'all want to, what's the end game? What do y'all want to do?
well,
What is your goal?
he needs to understand that due to no fault of our own, he's been in prison for a good while. He would like to plead guilty for concurrent
For what?
time served on the new charge, evading
For evading
detention.
arrest or detention?
Evading detention with
Which is, hold
previous,
on,
it would be a misdemeanor, but for 2 priors makes it a state jail felony.
That's correct, Judge.
Which-
However, he doesn't have more than 2 months of credit on
and this aggravated robbery in 03 doesn't affect
It doesn't
the
affect-
state jail felony
it doesn't affect
under
it
the
at all.
way it's indicted.
And he's kind of getting a raw deal because he's been in prison a good while, would like to get credit for all that, but since they didn't put the detainer on him until December the 12th of this year, he's only got
Is that
2
right?
months of credit.
Yes, Judge. I'm
So, okay, math, it's all math. How much is it? How long has he been in jail? How long have you been in custody?
I've been in custody 2.5 years, sir.
2.5 years. Okay, this is a state jail felony, my God.
It's a state
He
jail
can't,
felony.
he can't get more than 2 years.
Right. Well, we could do 180 days, but he's still got more time to do because he didn't get credit for this.
Yes, Judge. It's a system
What does it
error.
take for him to get out now?
Make it a misdemeanor.
Or-
Just going.
So even 100 days? He doesn't
He
have
doesn't
credit
have
for 100
his-
days?
He doesn't have 180 days.
180 days? Huh?
No, he's got 2 months worth of credit. He's got basically 60 days.
All right. Verify that, please. I want to know how much time he's given credit for.
It. Morgan. And Lacey ran, talked to the sheriff's office and they didn't place the detainer until December.
December 12th.
Yeah, so.
We could do 1244B
Okay.
and just open it to misdemeanor.
1244B misdemeanor, the time. Okay.
It's a state jail felony, but he's punished as though it were a class A misdemeanor.
Yes, instead of that.
Which takes care of it, gets him out of here.
Yeah.
Okay, y'all work it on. Let me know when you're ready.
Okay.
If you want to.
Let's see.
Judge, I got a plea for you.
Oh, you do?
I got one sent to
You personally or someone you're representing?
Someone already.
Oh, I was gonna say something long overdue there. Come on up.
All right. It's with Miss Alicia. Milton Richard. We sent that to you.
What's yours?
Judge, I've got Bryce Smith. It was on the afternoon docket. I had it
Oh.
up to the morning docket, sir.
Oh,
The add-on, sir. Should be the bottom of your steps. Oh.
okay, but it's not in the written. It's not in the
No,
written
I just
word.
gonna forward it on.
Okay, all right, let's do this, then I'll post it up that.
Thank you. Yes, sir.
Who do we need?
Milton Richard.
Milton Richard.
Thanks.
There's gonna be Bryce Smith.
Yes, Your Honor.
Is it just one case?
Yes, sir.
Yes, sir.
Go over there, this lady, she's gonna swear you in. Thank you. We've got two cases, right?
Yes, sir. And
What are we gonna do on?
180 days on.
Each?
Each dismissed the misdemeanor.
And do what?
And dismissed the misdemeanor.
Okay.
180 days on each case.
There we go.
And we have two cases called 25 CL 188 and 1689, the state of Texas versus Milton Richard. That's you?
Yes, yes.
Present with your attorney, Mr. Adams, and the state's attorney. Does the defendant waive formal readings of the indictments and the arraignments here? Can we proceed in sum?
Yes, sir.
In summary, looks like each of these similarly allege that in 1688 on or about July 10th, 2025, and in 1689 on or about June 30th, 2025, both in Jefferson County, Texas, you committed thefts. And because you have two or more prior theft convictions out of county courts of law or the criminal district court, then every time you steal a pack of gum, it's a state jail felony. And that's the way you don't want to steal, because it's something that would just be a little classy misdemeanor is now a felony every time, because that's the way laws are built because of criminal history as well as the circumstances of the crime. So you've got to quit stealing, or else it's always a felony. Do you understand what you're charged with?
Yes, sir.
These state jail felonies mean you face, in each case, no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand the punishment ranges for each cases? Of the case. Well, the deal's the same.
Yes, sir.
In each of these cases, the parties have agreed that you would be sentenced to 180 days in the state jail on each case to run concurrently. And looks like misdemeanor case would be dismissed.
Yes, sir.
Is that your understanding of the plan?
Yes.
If I follow these agreements, you have no right of appeal of your cases. Do you understand?
Yes.
How do you plead in each of these cases? Guilty or not guilty? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will, and because you are guilty as these are. Yes?
Yes.
Okay. And then paragraph 2, which alleges these prior convictions in 2023 of County Court of Law 2 of Jefferson County, June 20th, 2024. That's a special day for me. June 20, by the way. County Court of Law 2 in Jefferson County, Texas. And finally, February 24th, 2025 in this criminal district court. You were convicted of theft in each of those cases. Are those allegations true as they are alleged?
Yeah.
And are you pleading true and correct to that voluntarily? And because it is true as it is alleged for those 3 prior convictions?
Yes.
Yes?
Yeah.
Okay. I'm going to show you here what's marked as States Exhibit 1. I'm going to ask you, did you sign the documents? Did you understand it? Discuss it with your attorney? Is everything true and correct there?
Yes.
States Exhibit 1, tendered into evidence
No, yes.
without objection, it's admitted. Among other things, this states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any 11 lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, it states, so help you God.
Yes, yes.
Correct? Yeah, you have to speak out so she can
Oh,
hear.
yes, yes, sir.
Yeah, or else the record is absent and then we gotta fix it. All right, State's Exhibit 1 is made part of the record for all purposes and it's submitted into this hearing in each of these two cases. Pre-sentence reports are waived.
Yes, sir.
I'm going to follow these agreements, Mr. Richard. I'm going to find in each of these cases, you have pleaded guilty to state jail felonies of theft and true to these prior, 3 theft convictions as alleged in paragraph 2 in each of the indictments. You are making your pleas voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty pleas from State's Exhibit 1 admitted in each of these cases to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in each of these cases of these state jail felonies. I am following these agreements. You are hereby sentenced to confinement in the state jail for 180 days in each case. These are going to run concurrently. There will be, and this third case, which is, it looks like a trespass,
Yes, it's just.
will be dismissed as part of this agreement. Do you understand what has happened today? You're going to be given credit for all time you have served, but the jail figures that up, not us. The jail does. If there's a problem, call him. I'll be close. The way, what's it showing his credit? This is unofficial, but we're always closer, just perfect on it. But she's showing, Emmett,
Just 100, around 100.
she's just showing 100, but you know what it is. And the jail does. The jail does. Sometimes we don't get the data for us because that's not what our responsibility is for the jail. But if there's a problem, you let him know.
It's right at about 180, but again, the jail's gonna have to verify. And those are.
Just stand by. Hold on. There are 2 cases and I'm having to duplicate to work on the second one to make all the papers work out. And it says everything is taken. So good. We're set to go. Good luck.
All right, good luck, brother. Take it easy, man. Not now, but I'll get you something.
Say it again.
Yes.